May it please the Court, Jason Burnett for the appellant, R.J. Reynolds Tobacco Company. My plan is to reserve 5 minutes of my time for rebuttal. Judge LaRose. The two issues in this appeal do not require the Court to address any new or complex issues of law. Rather, the issues here require the Court to apply the well-established standards for summary judgment and for the admission of lay opinion testimony. For summary judgment, the law is clear that the moving party to be entitled to judgment must show that the evidence is conclusive, meaning that no reasonable jury could find for the non-moving party. The law is equally clear that a jury can reject expert testimony so long as there is a reasonable basis for doing so. And the law is also clear that a defendant, like Reynolds in this case, does not have an obligation to introduce affirmative expert testimony to contradict expert medical testimony by the plaintiff in a case where the plaintiff has the burden of proof on that issue. Nothing I've said so far should be controversial, and each of these points establish why the trial court legally erred in granting partial summary judgment to the plaintiff in this case. Dr. Villa's opinion on smoking causation was not conclusive. Dr. Villa relied on an inference from population-level epidemiological studies showing a statistical association between smoking and the type of lung cancer that Mrs. Maloney had. By definition, an inference is not conclusive, right? There's always a gap between the predicate for the inference and the conclusion that's inferred. And so we don't have conclusive testimony from Dr. Villa in this case about whether the lung cancer that Mrs. Maloney had was caused by smoking. But even apart from that, Dr. Villa did not have a complete and accurate picture of Mrs. Maloney's medical history. Under the Florida Supreme Court's decision in Wald, which is what tells us that a jury can reject expert testimony if there's a reasonable basis for doing so, one of the reasonable bases identified by the court in that case expressly was that if the expert has an incomplete or inaccurate medical history. And we know that's true of Dr. Villa in this case because in his deposition he said that there was no family history of cancer, and that's not true. Mrs. Maloney's mother died at age 62 from lung cancer. Mrs. Maloney's sister also had lung cancer. Their medical records show that. There's no dispute that that's the case. So we know under Wald that the jury could have rejected Dr. Villa's smoking causation opinion on the basis of this incomplete and inaccurate medical information that he had. He simply didn't know or forgot that this was in the record in this case. And then third, on the cause of death issue, this court's decision in Brown versus Lunkus, applying Wald, the Brown case is from 2013, Wald is 2011, this court said that it is a reasonable basis for rejecting an expert's testimony if there are qualifications. There, the qualifications were hotly disputed. And here, Dr. Villa admitted that he is not a radiologist. He doesn't hold himself out as a radiologist. Yet, he opined that the white matter disease in Mrs. Maloney's brain is what caused her death. He had nothing but his ipse dixit to reach that conclusion. He just said it overshadowed the other causes. And the record is clear in this case that Mrs. Maloney, unfortunately, was suffering from a host of serious medical conditions in 2002, 2003, when she passed away. And importantly, the record's also clear that as far as Mrs. Maloney's cognitive decline goes, she was suffering not only from white matter disease in her brain, which there's evidence to show that that was connected to the radiation she received for her lung cancer. But in addition to the white matter disease, she also had vascular disease in her brain. And that her treating physicians at the time, and Dr. Villa in his deposition, acknowledged that those factors contributed, those factors being the diabetes, the hypertension, the peripheral vascular disease, that those factors contributed to her problems because they do affect the vascular condition in her brain. Mrs. Maloney presented with a gait problem, shuffling gait. That could be related to her peripheral vascular disease. And so Dr. Villa acknowledged, the medical records say, it was a multifactorial, quote-unquote, multifactorial symptoms and causes that were presented with Mrs. Maloney in 2002, 2003. So in the separate issue of cause of death, there was a reasonable basis for a jury to reject Dr. Villa's opinion that it was the white matter disease that caused her death. The only thing in Dr. Villa's testimony in his deposition was that she had it, was that she had white matter disease. We're not disputing that. She had white matter disease. He looked at the MRI to show that it was extensive. There was a medical record that says it's the most extensive white matter disease that treating physician had ever seen in a 60-year-old patient. But the question is, did it cause her death? And there's nothing but Dr. Villa's own say-so that it was the white matter disease, other than the diabetes, that contributed to the vascular disease in her brain, the hypertension that contributed to the vascular disease in her brain, the peripheral vascular disease that contributed to the big shuffling gait problems that she had at the end of her life. This is a classic jury question. When you have multiple causes, we give that issue to the jury. There are separate instructions for concurrent causes. These are quintessential jury questions. Causation generally is a quintessential jury question, but particularly when you have multiple causes, those are the types of questions we assign to the jury. And all that is required is that there be a reasonable basis for the jury to have questioned Dr. Villa's opinion. There is no obligation for Reynolds to have introduced affirmative expert testimony to provide these points. We had them from Dr. Villa himself. We asked him, what are the other risk factors? What are the other causes? And he listed them out. He listed radiation, infection, chronic inflammation, asbestos, genetics. He said there are unknown causes of small cell carcinoma. And so that is information that the jury could have considered in weighing whether the plaintiffs had prevailed on their burden to prove by a preponderance of the evidence that the small cell carcinoma was caused by smoking, and that Mrs. Maloney's death was caused by the lung cancer and the radiation treatment for it. Now, the only indication from the trial court for the basis of its decision was that Reynolds did not have an expert, that we had no evidence. Well, no evidence isn't true. We had Dr. Villa's on testimony from his deposition. But it is true that Reynolds was not going to call an expert for these issues. But again, the law is clear under the Mack decision that we've cited, the Rice v. Everett decision from the 5th District from 1994. It's wrong as a matter of law, the Rice court said, to say that you have to introduce counter expert testimony when the plaintiff brings forward medical expert testimony. You don't have to do that. You simply have to give some reasonable basis for the jury to question the plaintiff's expert or the other party's expert. And there has to be some reasonable basis that would lead a reasonable jury to conclude that the plaintiff had not carried their burden of proof on that issue. And so those are the reasons that the trial court legally erred. Of course, this is the de novo question. And so the reasons for the trial court's decision really aren't an issue. We're not trying to analyze whether the trial court abused its discretion.
Seems like your position is that summary judgment on the question of whether the smoking caused the cancer was based on the syllogism, I'll call it, of the doctor, which is that small cell carcinoma is a bit of a tautology, but it's caused by smoking 99% of the time. Therefore, was it caused by smoking? How do you know? Because it's always caused by smoking. But I'll leave that aside. Because she smoked so much, therefore it caused it. So would that, if that went to the jury, would you have moved for directed verdict because that's not enough, or would if a jury could find causation there? Could a jury find causation based on that? Right?
Yes, we did not challenge.
So if that's the case, and as you said, the doctor said, well, I can't ever prove in an individual case. It's based on epidemiology. Then, if that's unrebutted, then why is that not enough for a summary judgment in favor of the plaintiff? I'm talking about causation. Smoking caused the cancer.
Sure. On the statistical analysis, right. It creates a jury question. We didn't challenge Dr. Villa's ability to opine on that in the trial in this case. But it creates a jury question, which means the jury could reject it and give what weight it would deem to that testimony. And yes, you're right, Your Honor. Dr. Villa said there's no way to look at the small cell carcinoma in a non-smoker and the small cell carcinoma in a smoker and determine what the cause of that small cell carcinoma is. You have to use a statistical inference for a causation opinion. But we can make that argument to the jury, that you can give what weight, jury, you want to decide to that issue, because there is this inference being made. There is this gap. It's this gap. Dr. Villa said 99%. Well, that leaves 1% of cases in non-smokers.
Well, if you can never prove in an individual case, it's all based on epidemiology and statistics, then what court could ever, or are you saying you'd never have summary judgment on that issue? It always has to go to the jury?
Well, I mean, there will be a different factual record in different cases.
But it may be that she never smoked, she hardly ever smoked, but here she smoked all the time, right? That's the uncontradicted evidence.
She was a persistent smoker from about 1959 to 1996, correct. So, yes, I think this is, I mean, the general rule is that causation issues are for the jury, right? We know that. That's what the jury's role is, to decide these causation issues. And yes, there's always going to be an argument, I guess, from the defendant's standpoint as to the application of this statistical analysis. But that's a question for the jury to sort out and to give what weight it can. And remember, for the smoking causation, smoking causing the lung cancer issue, we not only have the statistical inference, which, again, it's not conclusive if it's an inference, but we not only have that issue, we also have the issue of the inaccurate and incomplete medical history that Dr. Villa had. So there are other causes of small cell carcinoma. Dr. Villa admitted that there are non-smokers who get small cell carcinoma, and he listed the factors, I read them, of what small cell carcinoma can be caused by, and that includes genetics. We said, is there any other risk factors? And he immediately volunteered, well, there was no family history of cancer in the case. Well, that's not true. There is family history of cancer in the case. And so that also, in addition to the statistical problems with Dr. Villa's testimony, will be an additional reason why the jury could have rejected his opinions in this case. And again, I mean, the legal standard, we're not asking for a new rule of law or anything else. The law is clear as set out by the Florida Supreme Court in Wald. Is there a reasonable basis for the jury to reject it? And Dr. Villa, at the time that he gave his opinion, didn't know a very important fact about Mrs. Maloney's family history, the fact that she did have a family history of cancer.
And you're telling me there was from that expert, there was elicited the concession that genetics could be a cause of small cell carcinoma?
We did not ask him that question directly, and he did not say that directly. We asked him the question, are there other risk factors for small cell carcinoma? And the first thing Dr. Villa said, well, I didn't see any family history. He didn't say I didn't see any. There's no family history of cancer in the chart, which I guess means in the medical.
Inference could be drawn that he said that because he believed it could be caused by genetics.
Yes, Your Honor. Or it could be caused by either genetics or a common source that would have affected both his family members and Mrs. Maloney. So Dr. Villa also mentioned that radiation, radon exposure can be a cause of small cell carcinoma. If they were all exposed to asbestos, that would be a reason why all three of them would have lung cancer, potentially, or genetics themselves. And again, Dr. Villa said there are unknown causes. There are unknown causes for small cell carcinoma. It's not literally true that every small cell carcinoma case involves smoking. It's not true. And so, yes, the jury could have reasonably relied on these deficiencies in Dr. Villa's opinion testimony to reject his testimony. And of course, the standard instructions tell the jury you can reject the testimony of an expert, or you can accept it, or you can give it what weight you think it deserves, but you can reject the testimony. And so these are quintessential fact questions that are normally given to the jury, and we did have a record from which a reasonable jury could find that there was problems with Dr. Villa's opinions in this case. And again, the cause of death opinion suffers from the very serious problem that he didn't have the qualifications, and simply said, well, the white matter disease far overshadowed the other causes. I mean, this is not a situation where Mrs. Maloney had some minor health issues at the same time that she had white matter disease. This is a situation where Mrs. Maloney had very, very serious medical problems. Dr. Villa even said, yes, if it hadn't been for the white matter disease, then these other problems would have been a significant problem for Mrs. Maloney. He acknowledged that they would have contributed to her death, even apart from the white matter disease. But he simply said it was far overshadowed by the white matter disease. Well, okay, you say that, but you provide no basis for saying that. And you yourself you're not a radiologist. You've admitted you're not a radiologist. And so it's for the jury to think, well, diabetes, uncontrolled diabetes. I mean, there's no question she had uncontrolled diabetes in the medical records from her treating physician, hypertension, peripheral vascular disease. There's no question that she had these things, and the jury gets to decide, well, was that actually the cause of her death? I mean, this is a smoking and health case, a wrongful death case, and there wasn't a single medical expert to testify in this case. The two experts that testified for the plaintiff were Dr. Cummings, who has a PhD in public health, and Dr. Herkoff, who's a clinical psychologist. The trial judge prevented them from giving a medical opinion. They tried to get it through Dr. Cummings. They asked the question, to a reasonable degree of medical probability, do you think the addiction caused her death? And the trial judge said, whoa. He's not a medical doctor. He can't give that opinion. So it's very unusual to have this medical case without any medical expert testimony, because the trial judge granted summary judgment and took that issue out of the case, which of course is why it's harmful error in this case. Now, the main argument on the other side is that, well, the jury also answered this question about product use. Was it smoking of Reynolds cigarettes that caused the disease? Well, the jury did answer yes to that question, but of course they were instructed by the trial judge. The trial judge had determined that the carcinoma was caused by smoking and that the lung cancer caused the disease. So if the evidence had come into the case that, in fact, there were reasons to doubt whether the carcinoma was caused by smoking or whether the lung cancer had caused her death, then they might not have answered yes to that question. That doesn't prove that the argument is harmless at all.
You're up to 15 minutes.
Okay.
Use your time as you will.
Okay, thank you, Judge LaRose. Just quickly on the lay opinion issue, sometimes as an appellate advocate I have a difficult time explaining to a panel how a court abused its discretion. So we're moving from a de novo issue to an abuse of discretion issue. Here you have a very clear reason why. The trial court judge, in making its ruling, both before and after trial, said that because the lay witnesses could lay a predicate and describe their personal observations, then they could also give an opinion. That's exactly the opposite of what the statute says, 90.701. It says if lay witnesses cannot readily communicate in terms of their perceptions, then they can resort to an inference or opinion. But otherwise, if they can describe their perceptions, and they did here, the daughters testified that Mrs. Maloney smoked first thing in the morning, all the time, got up in the middle of the night to smoke. There was plenty of evidence about the personal observations. There was no need to usurp the jury's function and then draw the inference that she was also addicted. And the reason it matters in this case, because at the end of the case, in the closing rebuttal by plaintiff's counsel, we had made a real issue out of the two experts they had brought to talk about addiction and how they conflicted with each other on the tests that they applied. And the plaintiff's counsel said, well, put that aside. We have two disinterested witnesses, because the two daughters weren't on the verdict form. Two disinterested witnesses said that, in their opinion, Mrs. Maloney was addicted. And so they don't have a dog in the fight. So you can trust their opinions. That's why it makes a difference in this case. None of the cases that have been cited on the other side apply 90.701. That statute is clear. Again, we're not asking for a new rule. We're just asking that the statute be applied to this issue. Thank you, Your Honors.
Thank you. You have about 3-4 minutes of rebuttal, okay? Good morning.
Good morning. May it please the court, my name is Courtney Brewer for the appellee, the estate of Carolyn Maloney. This court should affirm the trial court's determination that there was no material facts in dispute because all of the evidence showed that Carolyn died as a result of lung cancer caused by smoking. Dr. Villa's first opinion about small cell lung cancer having been caused by smoking, as has been noted, he testified that smoking is associated with small cell carcinoma in 99% of the cases.
Let me ask you a question
Yes.
about that. Would that mean that in every smoking case that the plaintiff would be entitled to a summary judgment on that issue if the expert testifies to that statistic?
If the expert testifies to that statistic, if the smoker has a heavy smoking history, as we had here with 37 years of smoking and multiple packs per day, and if there is no evidence presented to the contrary, no evidence of any of the other risk factors being met, Reynolds didn't present any testimony about her having been exposed to any of these toxins, having the infection.
Didn't Dr. Villa testify about genetics could play a role?
He testified as to the other risk factors. I'm not aware that he brought up genetics. First of all, genetics clearly couldn't cause lung cancer. Just because your mother has lung cancer would not cause you to have lung cancer. It would.
That was their argument. I'm just trying to understand if you get this, if you have this opinion on the statistical relationship between small cell carcinoma and lung cancer, I'm not understanding why you just, if you have that, your expert testifying to that, why in every case you wouldn't get a summary judgment based on that?
Well, if you had these facts, then you should get a summary judgment based on that, because there is no evidence to the... Reynolds had the opportunity in the deposition of Dr. Villa to ask him about the genetics and what role it played, and didn't do so. Mr. Burnett was talking about how he testified about the family history in the chart. But that was all clearly in the context of these occupational hazards. And Reynolds never followed up to say, hey, what about the fact that her mother had lung cancer? And by the way, the testimony was that her mother smoked as well and developed lung cancer, and the evidence about the sister is in one of the medical records that she had lung cancer. In another place it says cervical cancer, and maybe it was both, but in any event, the testimony, Reynolds had the opportunity at summary judgment, and the rule on summary judgment, we don't even have to get to Wald versus Granger, because the rule is if we put forward the evidence that shows our case and it is not disputed by the other side, then the burden shifts to them to put forward something, some basis, some grounds for saying that the statistics lining up in this case doesn't matter, or that it should be an issue for the jury. And that's just not the case here. And in addition to the smoking causing the lung cancer, Dr. Villa also testified that her cancer led to her death because the radiation treatment she received after the cancer metastasized to her brain caused her white matter disease. And that's consistent with the medical records in this case. It's consistent with the death certificate, which listed lung cancer as her cause of death. And there's no evidence to the contrary to show that there was anything else at play in the case.
But the doctor, excuse me, sorry, said that it overshadowed other possible contributors. Doesn't that create an issue of fact?
He testified that diabetes and hypertension, if they played any role, played a minimal role. It doesn't create a question of fact, Your Honor, because they never put forward any evidence to show that that is in conflict at all. The diabetes, I mean, if it had said diabetes on the death certificate, or if there had been some medical record saying she died from diabetes, then you have this genuine issue of fact, and that would be properly submitted to the jury. But here you only have Dr. Villa's testimony, which is she died from the white matter disease, and that is consistent with the record. It's consistent with the testimony at trial about what she was like leading up to her death, and all of the medical records at the time talking about how this is the worst case of white matter disease, and that she's basically, her brain is degenerating, and that's what the evidence at trial showed, and the evidence on summary judgment showed. And to the extent the court gets to Wald v. Granger, or this court's opinion in Brown v. Lunkus, there is no evidence on the other side. I mean, it's similar to the summary judgment standard. There's no medical expert testimony on the other side. There's no real impeachment of Dr. Villa's testimony in this. There's no pointing out, hey, you missed this factor, or you had this wrong about the plaintiff's chart. This court's opinion, for example, in Fell, talks about how an expert's testimony can be impeached by the fact that they're giving the plaintiff the benefit of the doubt when there's subjective complaints of pain.
You said that there was nothing, but counsel for the appellant pointed out that there was an exception to the requirement that unrebutted expert testimony be credited, and that is that testimony, essentially had an incomplete picture of the facts, and you acknowledge that the record at least includes that there was evidence of cancer in the family, and you pointed out, both counsel pointed out, that's not just genetics, that is essentially an open door to the possibility that there were environmental factors in common between the family members. So isn't that a jury question? Doesn't that create a jury question that because they're capable of rejecting that unrebutted testimony?
Well, no, Your Honor, because Dr. Villa was never asked, did you consider the genetics? I mean, he never testified that he didn't consider this. He never testified that and what role that would play, and that was incumbent on Reynolds at that point to, But they elicited from him that he didn't know that. No, I don't think that that's what the record shows. I think that the record shows that he was asked about the other risk factors. They mainly were covering occupational hazards. They said, did you see any of those risks in her record? And he said, well, not from the chart or the family history. She was a beautician, so I don't think that And so clearly talking about these occupational hazards. And it really, the burden had shifted to Reynolds at that point to ask the question that they claim is lacking. And Dr. Villa, again, family history is a risk that might make it more likely for her to develop lung cancer, but it didn't cause her lung cancer in this case.
Let me ask you a question. If we were to conclude that this actually wasn't appropriate for summary judgment, we'd still have to look at this for harmless error. So would you address that? Because I believe as the beneficiary of the error, you would have the burden here to convince us that it was harmless. So would you address that? Sure.
Well, the jury had to had to answer the question, did Reynolds' cigarettes, so there was a brand issue, did Reynolds' cigarettes, did smoking of Reynolds' cigarettes cause Ms. Maloney's lung cancer and death? And answered yes to that question.
Their position on that is they had already been instructed about that, and it was just a matter of tying that up to Reynolds.
Right. I'm sorry, Judge, can you rephrase that for me?
Well, I am having a hard time seeing why this isn't a classic jury issue, both of these points. And I haven't made up my mind about that, but in case that, I or the panel feel that that's the case, I want to give you an opportunity to address whether or not if that was an error, it was harmful.
Well,
harmless, excuse me.
Sure. Because the jury still couldn't infer that there was any other cause of her cancer or her death. There is no evidence that Reynolds has ever put forward that would allow the jury to infer that. I mean, that's what Wald gets to, that you would have to reverse a jury verdict if it had come to that conclusion. What inference could the jury have drawn from Dr. Villa's testimony? Or putting aside Dr. Villa's testimony, the only other evidence in this case are the medical records and the death certificate, and all of those point to lung cancer that caused eventually her death, and that lung cancer was caused by smoking. So to the fact that it's harmless is because there's just no evidence to the contrary that they've ever pointed to that would allow the jury to infer that.
Maybe I want to make sure I'm following. So if there was error to grant summary judgment because there was issues of fact, are you explaining that was harmless because at trial there is no way that a jury could have found by the preponderance of evidence that it was not, that the smoking was the cause of the cancer and the cancer was the cause of death? Because at summary judgment you get to go to trial and then the defendant gets to put on more evidence or different evidence or do more discovery. So
it would be very difficult to argue that that we could get to harmless error because there's no trial court record to see what all was developed. And what I am saying is that there is no evidence. Reynolds has still not presented any evidence that there is any other cause of her lung cancer here. And they haven't come forward with any, not that they could come forward with evidence on appeal, but they didn't present it at trial. They didn't present it at the summary judgment stage. Why would they present it at trial? Right. Well, I know, and that's why this harmless error debate is a little weird.
Yeah, but it's still your burden, and we still have to analyze that. And,
right.
And I think their argument is not based. I think their argument is based on we didn't have to come forward with any evidence. All we have to do is show that a reasonable jury could have discounted your expert's opinion.
And I do not see how a reasonable jury could do that. There was no evidence that genes cause small cell lung cancer. There's no evidence of any other cause in this case. They didn't even really impeach Dr. Villa on any of the things that they say Dr. Villa didn't consider. If you read through the deposition testimony in this case, Dr. Villa very clearly states, consistent with all of those medical records and all of the death certificate and everything we know about this case, that she her small cell carcinoma was caused by smoking, as it is in 99% of the cases, and certainly as it is when someone smokes as much as Mrs. Maloney did, and again, consistent with all of the medical records and the death certificate in this case. And so, do they have to present evidence? I think under Wald, under the summary judgment standard, they have to present some basis for the jury to not believe Dr. Villa, to find that there is some other inference in this case. And I just come back to, what's the other inference? What's the other cause that Reynolds contends caused her to have lung cancer, that it caused her to die? And not just speculative inference, but an inference based in some sort of evidence. And we just see none of that here.
I don't know if you were going to go to the evidentiary issue.
I was going to, but I'm
Well, I just
welcome
was
another
gonna ask you
question.
why was it necessary, why was lay opinion test necessary to communicate what those witnesses perceived, which is, she smoked when she got up?
Sure. What is necessary, and so, let me get right to that question. So, what is necessary in this case? They talk about how the lay witnesses could just testify to the smoker's behavior, that the smoker gets up and the first thing in the morning she smokes a cigarette, she smokes 3 packs a day, and she finds it very difficult to quit. And while we present that evidence in every case and presented it here, Reynolds always comes back with, yeah, but how do you know that wasn't just her choosing? Didn't she just like to smoke? Isn't that why she did it? It wasn't that she was addicted. And while I don't want to play into that dichotomy, because I think that these issues are very intertwined, and I think the 4th DCA recently recognized that in the Collar decision, this notion that the lay witness can say, no, I didn't look like a choice to me, it looked like she was addicted, is a very important feature of this trial. Being able, and addiction is something we know from the case law, that an ordinary person with, intelligent person with a degree of experience can testify to, because the case law about, that downward departures, the downward departures in sentencing cases where someone can say, I was addicted and that's why I should get a downward departure, or the dram shop cases where we hold bars liable for serving alcohol to someone that they should have known was habitually addicted to alcohol. And so those two features of the statute, that that the witness needs to be able to testify to that opinion, because otherwise the witness cannot readily and with equal accuracy and adequacy communicate what he or she has perceived to the trier of fact without testifying in terms of the inferences or opinion, and that it doesn't require a certain level of knowledge, skill, experience, or training. I think both of those are kind of encapsulated in this case law, and to the extent my brief doesn't do a good job addressing issue 1, I hope that I've made it clear here for you under the statute. And I have to point out that in arguing that there's an abuse of discretion in this case, the Reynolds hasn't acknowledged that 2 district courts of appeal in 3 different cases have affirmed the admission of this testimony. Those, the 4th DCA in Grossman and Brown and the 3rd DCA in Ballard, they had those issues presented to them. We've filed the briefing and it's in the record, and this court can look and see that it's the exact same argument about permitting the family members to testify to addiction, and in all those cases, and you had they were all unanimous decisions, and so you have basically 9 district judges as well as the 3 trial judges. They were all different trial judges in those cases, all saying that the evidence could come in. So the fact that the trial judge in this case went the way of 12 other judges, we think shows...
Those courts explained that opinion was necessary, or did they address that first prong of the statute where it requires that it's necessary for the witness to communicate where he or she is perceived?
None of the DCAs have gone into depth in explaining this. They just affirmed on the argument. The trial courts, I'm not recollecting off the top of my head whether they went into a great deal of detail about it, but I think that we made the same arguments or similar arguments to what, the plaintiffs in those cases made similar arguments to what have been made here today, and for those reasons I think we meet the statutory requirements. And even if we didn't, getting to a harmless error issue, and I know harmless error is a dangerous place to go and a hard place to go for the beneficiary of the but I will just say that the jury, in order to find that the addiction caused her disease in this case, had to credit the testimony of Dr. Cummings, who also testified that she was addicted. And I just don't understand, I can't fathom how the jury could have disregarded what Dr. Cummings said about the addiction, or found that incredible, yet found that the addiction caused it, credited his opinion as to that. And so on those 2 points, we would ask that this court please affirm the decision of the trial court below if there are no further questions. Thank you.
Ms. Brewer. Mr. Burnett.
Thank you, Your Honors. I think one of the key issues is whether Reynolds had to introduce other evidence, quote unquote, and I think the Wald decision from the Florida Supreme Court, again, does address this. It says that a jury can reject expert testimony if there's conflicting evidence, so that's other evidence, right? But also if the expert is impeached and if the expert had an incomplete or inaccurate medical history, which is the case here. And so those two latter examples don't require other evidence. The impeachment of an expert, the credibility of an expert, doesn't necessarily require affirmative other evidence to come in.
Well, so let's say they weren't, we decide he wasn't impeached, and the inference that you want us to draw that he didn't know about the family history, we don't agree with for the sake of discussion, and you were relying on other evidence in a sense by saying that some of his testimony gave the jury the ability to draw inferences. Counsel for appellee has said they can't be speculative inferences. Is that something the case law supports?
I don't see anywhere in the case law whether there's speculation or not. It has to be a reasonable basis. So reasonable normally would not allow for speculation. But in this case, there's no need to speculate as to whether there's actually a family history of cancer in Mrs. Maloney's family.
The speculation would be, there's one step further, which you have to connect the two dots. Someone else had cancer, you had cancer, and what? There's a genetic connection or there's an environmental connection.
Sure.
Would that be speculation?
No, when it comes to weighing the plaintiff's testimony, it would be speculation perhaps if we had affirmative obligation to prove that it wasn't actually smoking, but it was radon exposure or it was a genetic problem in running in Mrs. Maloney's family. But we're simply asking the jury to take into account the deficiencies and the shortcomings in Dr. Villa's testimony, which includes the family history that Dr. Villa did not consider. He was simply wrong about that fact. The Mack case from the first DCA lists the other potential causes, the possible causes. It only needs to be possible for it to come in for the jury's consideration. That's what Mack says from the first DCA, and that's what the Haas case says, H-A-A-S, from the fourth DCA. Other possible causes get to come in for the jury to consider that. And here, the Mack case from the first DCA specifically noted a genetic history as a potential other cause that the jury should be able to consider. So it's not speculation when it comes to understanding what's the basis for the expert's testimony in the case. Now, we're not speculating as to whether he rightfully or wrongfully excluded as part of a differential diagnosis, whether there was some family history of cancer. There's no speculation as to that. And there's no speculation as to the further step. Well, was it genetics or radon that caused the cancer? We're not trying to prove that necessarily. We're trying to diminish the weight of the expert's testimony in the case so that the jury can consider the testimony and the basis
Maybe less
for
than
it.
conclusive?
I'm sorry?
Less than conclusive?
Yes, yes, less than conclusive. Just to create a jury question on that. It has to be conclusive for summary judgment, Your Honors. On the death certificate, just quickly, Dr. Villa himself acknowledged that death certificates have loads of problems. They have significant error rates. We cited the Marshall case, which says that they're not even prima facie evidence for the cause of death. So the fact that the death certificate in this case has lung cancer, Dr. Villa himself didn't rely on that, and the case law is clear that it's not even prima facie evidence of the cause of death. It's only prima facie evidence of the place and time and date of death. And then counsel for the other side said there's no evidence, again on this theme of no evidence that Mrs. Maloney, died of diabetes in the record. Well, there's no evidence that she died from white matter disease in the record either. The medical records just say that she had white matter disease, and it was Dr. Villa's testimony that tried to connect the dots. But it's the same as diabetes. There's no medical record the medical records are clear she had diabetes, and it was simply Dr. Villa's testimony that it wasn't diabetes, but it was rather the white matter disease. And again, this is just a classic question of causation, multifactorial. Again, Dr. Villa's testimony in his deposition and the medical records, I think like 5835, say this is a multifactorial case we're being presented with as Mrs. Maloney's treating physicians in 2002. She's got a host of problems. I see white matter disease, but I also see uncontrolled diabetes. And Dr. Villa acknowledged it was causing vascular disease in her brain. So this is an unusual case where we're not talking about simply one aspect of an expert's opinion. We've got three different issues that we could have presented to the jury in an effort to undermine the weight of Dr. Villa's testimony. And that's what the case law allows us to do, to create a jury question on those issues.
You can wrap it up, Mr. Burnett.
Time's up. Thank you, Your Honor.
Thank you.